Welcome to Education in Focus. I'm your host, Eliana Kernodle. A California lawsuit alleging a school district's parental notification policy for student gender identity violates teachers' First Amendment rights will continue after a judge denied motions to dismiss the case last week. Joining me to dig into this is Chalkboard News editor Brennan Clary. Brennan, before we get into the latest developments, can you give us the background on this case?
Yeah, sure. So essentially, two teachers, Elizabeth Mirabelli and Lori Ann West, they filed a lawsuit in April of 2023 against the Escondido Union School District, the California Board of Education, and Rincon Middle School over a series of policies regarding the handling of gender diverse or transgender students. And so essentially the school's policy said that if a student has a pronoun change at school, if they want to go by a different name or pronoun at school, then you cannot tell parents about it. And so there was even emails sent to staff that included lists of students who were socially transitioning at school, but had restrictions on who you could talk to at home with their parents about their gender change. And so they had kind of a list of, here's who you can talk to. Dad, he knows, or like the mom knows. But don't tell the other parent, sort of thing. And so these teachers filed a lawsuit and they said that violates our First Amendment. You're compelling us to essentially lie to parents, even if they asked us, what are we supposed to say? And so they're feeling like, okay, I'm in a very uncomfortable position here because of this policy. So they filed a lawsuit. And that's been continuing. So there's been, several developments in that case. And so that's the background there of, okay, we have parental notification policy in terms of not telling parents what's going on at schools. And so that is currently the policy. We've also seen other litigation in California, a background. Just there's been a lot of debate around these kinds of parental notification policies. Like, should schools have an obligation to tell parents if there's a change to their students' gender identity at school? And also, just a little bit of background too, a lot of voters, when they're polled, they say that parents should be involved in these kinds of decisions. So this is sort of, to go the other way, is sort of an outlying position in terms of what voters think nationwide. So at the Center Square's voter voice poll last year, they had several questions, and consistently voters said parents should be clued in on these kinds of decisions or these kinds of changes to their student while at school.
And getting into the latest developments, what was the reasoning behind the motion to dismiss, and how did the court respond to that?
Yeah, so that's a great question. Essentially, there was two different kinds of arguments coming from the school district and also the state. So the state and school district had different kinds of arguments, and they were both asking the judge to throw out the lawsuit. And the school district said that the state was making them do this, and so that they didn't really have a choice. But the state said, you need to have this kind of policy. Then the state says it's not actually a policy that you're required to do. It's not a law. It's just a suggestion. So they're saying like, hey, we have this, and really it boils down to, it's even not like this is a mandate or like a state board of education order for schools or a memo, in the way that like an Office of Civil Rights dear colleague letter, like sort of that has the effect of law, even though it's, sort of an enforcement kind of thing. It's not really even like that. It's more like a frequently asked questions page on the California State Board of Education or the Department of Education website. So, and then it really gets into, it says on that like FAQ page that schools need to prioritize the rights of transgender students. And so that's really what it says. And so then the question is, does that become binding guidance? Or is that more of a guideline? And in this case, now the state is saying, well, that's not actually binding. We're just saying that as like, that's a suggestion. Like, we're going to back away from that legally. And the judge in this case said, like, that doesn't quite line up. So he said, the state defendants argued that even if plaintiffs do have the standing, and this is like a continuation of their argument too, is that even if the teachers and parents do have like standing here, that they actually lose their constitutional rights at the schoolhouse door, so that your parental rights are diminished while your children are at school. So I think that this is kind of a another argument of saying like, well, if your kids go to a government funded school, they go to a public school, they have their own rights, and that yours as a parent are diminished when they enter that line. That is what the state of California is arguing in this case, and that whatever parental rights remain are subordinate to the child's newly state-created right to privacy and the child's right to be free from gender discrimination. So it's kind of like the state has a position that when kids are at school, they have this new right to be free from gender discrimination, that they can sort of create their own social identity, and that they can do that away from their parents. And the judge, Roger Benitez, said, no, the Supreme Court has long recognized that parents hold a federal constitutional due process right to direct the healthcare and education of their children. So he said, like, federally longstanding precedent shows that kids are beholden to their parents. Like, parents have the right to determine what their children should be doing and to make those decisions for them because they're not adults yet. And so I think that's kind of one of the central questions here is, at what point does a child have autonomy, and specifically over their gender and some of this identification? And so we're starting to get into, I think, the fringes of where the law kind of lays down on some of these issues, if that makes sense. So that is one of the bigger things that the state was arguing, along with saying that, you know, we're the school saying, hey, we're beholden to the state, and then the state saying, well, you know, we're just kind of walking that back a little bit here.
Well, and in this case, who is the defendant? Is it the state, or is it the school district, or is it both?
It's both. Yeah. So the state is the defendant, and then the school district as well. So they were sued because I think they sued the school district, and then the school said, well, it's the state that is enforcing this. And so then the state says, well, it's actually not as binding as we think it is. So they're both defendants. And so they're both on the hook. And so that's why they were both asking for the case to be thrown out. And the judge said, no, we're going to keep fighting this. And it's actually becoming a class lawsuit, right? So there are different parents now who are involved in different, and the teachers as well. And so if this was to be, as this keeps going, this is going to have huge ramifications for the state of California. And as we know, it's generally a progressive state. There's a lot of pockets of very progressive districts. And there's also some conservative districts. And so it's going to be very interesting to see how this plays out, you know, as litigation continues here and as it sort of tries to determine this. Because if this happens in California and it strikes down some of these parental notification, or, you know, it sets, here's the line on these parental notification laws, then I think that that's going to have widespread ramifications for the rest of the country too.
Well, Brendan, thank you for your insights on this story. Listeners can keep up with this story and more at chalkboardnews.com.